Good evening, everyone. Welcome to today's Belgrade Legal Theory Group meeting. My name is Mila, and I have great honor to represent Alexandra Marcescu. She's a lecturer at West University of Timisoara, Faculty of Law, and today she will be speaking about state emergency in Romania. The full title of her lecture is State of Emergency in Romania Towards Penal or Military Populism. I will remind all of you that this is the third lecture or meeting in the Syria state of emergency. 2 weeks ago, we had Pedro Muniz Lopez from Portugal, and last week we had Mateusz Gur from Slovenia. And now it's turn for Romania and for measures taken in Romania. Also, I will remind all of you that you can ask questions by raising your virtual hand in the right part of your computer. Or if you wish, you can type it in the chat box if you have problems with internet. So, Alexandra, the floor is yours.
Yeah, thank you very much. Thank you very much for having me. Thank you to Boya and to Miodra for having invited me. I want to give you a brief overview of the the whole context, the whole legal context of this crisis, and I will structure my presentation in two parts because I find all this crisis to be a story, and not only in Romania, I'm convinced, but at least in Romania, I see it as a story with multiple layers. And first, in the first part, I want to discuss the purely legal or strictly legal layers. Of course, there's no such thing as a pure legal aspect of something, but still, let's call them the more visible legal layers. And then, in the second part of my presentation, I would like to dig a bit into what's probably the less visible face of law. To dig beneath the surface and to discuss questions of culture and legal culture. When it comes to the constitutional framework, here the matters are quite clear. Article 93 of the Constitution, entitled Exceptional Measures, states very clearly that in accordance with the law, the President of Romania imposes the state of siege or emergency upon the entire country or upon certain territorial administrative units and asks Parliament for the approval of the measure adopted within a maximum time period of 5 days following its adoption. If Parliament is not in session, it will be convened by law no later than 48 hours after the declaration of martial law or the state of emergency and will remain in session throughout this period. This is exactly what happened. So the President declared the state of emergency upon the entire country and Parliament approved it. Now, the other article that's relevant from the point of view of the crisis is Article 53, entitled Restrictions on the Exercise of Certain Rights or Freedoms. It's nothing unusual. It basically states that the exercise of certain rights or freedoms may be restricted only by law and only if this is necessary, as the case may be, to defend national security, public order, health, or public morals, or the rights and freedoms of citizens to investigate the crime, to prevent the consequences of a natural calamity, a disaster, or particularly severe catastrophe. And point 2 states that the restriction can only be imposed if it is necessary in a democratic society. So we have here the 3 criteria: legitimacy, necessity, and proportionality. The measure must be proportionate to the situation which caused it, has to be applied in a non-discriminatory manner, and may not eliminate the right or freedom in question. I underline eliminate. So what can be restricted is only the exercise of certain rights or freedoms, not the right itself. So this regarding the constitutional framework. Now, the legal framework, so the infra-constitutional legislation that regulates the state of emergency, is actually, it's an act of government. It's an emergency ordinance that was passed in 1999. Of course, it was later on ratified, accepted by Parliament, and even modified. It bears mentioning that it entered into force, so this piece of legislation entered into force under the previous democratic constitution, post-communist constitution. Nowadays, under the current constitution, it would not longer be possible to regulate or even modify the state of emergency via an act of government, so only through an act of Parliament. So this piece of legislation, the statute, basically defines the state of emergency as the set of exceptional measures of legal, political, economic, and public order nature applicable on the whole territory, only parts of the territory, that are established in the following two situations. So there is a distinction: the existence of current or imminent serious danger to national security or the functioning of constitutional democracy. And the second scenario is the imminence of the occurrence or the production of some calamities that make necessary the prevention, limitation, or elimination, as the case may be, of the consequences of some disasters. Then it stipulates very clearly that the president issues a decree. And by the way, we can discuss whether this is an obligation or a right. Well, the language is quite imperative. It says issues, so I would suggest that it's an obligation if the state, if the facts, of course, impose it, issues a decree which must indicate, among all kinds of elements that are just, regular, nothing spectacular, but among other elements, the exercise of which rights and liberties shall be restricted. And I should also mention that Romania sought a derogation from the provisions of the European Convention of Human Rights that was registered at the Secretariat on 17th of March this year. It's also important to note from the perspective of human rights that during the state of emergency, the following are prohibited: the limitation of the right to life, except in cases where the death is the result of lawful acts of war, torture and inhuman or degrading treatment, conviction for unstipulated offenses, and restriction of the free access to justice. Apart from these four categories of rights and liberties, the other rights can be limited, but only in accordance with the Constitution, so in accordance with that article, which clearly stipulates the three criteria, namely legitimacy, necessity, proportionality, and true law. Okay, let me see. Now, this piece of legislation also provides for a transfer of competencies from central and local civil administration to military authorities or other special authorities. And here we have a distinction. So if the state of emergency were to be established on the basis of the first reason, so grave actual or imminent danger posed to national security or the constitutional order, then it is the Ministry for Internal Affairs that will coordinate the implementation of the measures that are necessary. Whereas if the state of emergency is established on the basis of the second reason, so calamity, something related to a catastrophe, imminent or that has already been produced, then it's a so-called National Committee for Emergency Situation that will deal with the crisis, and that committee will be indeed coordinated by the Ministry for Internal Affairs and also the Prime Minister. In any case, the Ministry for Internal Affairs has the right to issue military ordinances and orders, which are, of course, binding. It happened like that. So we had a number of 12 military ordinances, and we also had this transfer of competencies from central and local administration, civil administration, to military administration. In the case of hospitals, for instance, we had hospitals that have become quote unquote militarized. So these measures that are taken by the Ministry for Internal Affairs in these military ordinances, they can trigger sanctions. It's important to know that they have to be, so the military ordinance itself has to be within the limits established by the president's decree, and the decree itself has to abide by the Constitution. And it's also important to know that in principle, these military ordinances can be subjected to administrative judicial review because they are administrative acts. Okay. Now, the case law framework, or the layer, the jurisprudential layer, there's a layer that comes from the courts in the story, because the Constitutional Court was given the opportunity to discuss some issues related to the implementation of the emergency state upon request by the People's Attorney or the Ombudsman. It happens to be a woman. So, and incidentally, in this decision that was actually rendered on the 5th of May, and we now have the complete ruling, the arguments of the judges very interestingly, they discussed the nature of the president's decree from the point of view of the law and the type of control that can be exercised upon it. I say incidentally because this was not the main claim. So basically the People's Attorney just wanted to prove, the People's Attorney claimed that this piece of legislation, so the infra-constitutional legislation that regulates the state of emergency, contains some articles that are unconstitutional. And those articles on the basis of which the police applied fines. And probably you know this, we were on BBC Front's page. Romania collected huge amounts of fines during the crisis. So this was the main claim, but interestingly, the judges decided to discuss the nature of the president's decree, and we have a divergence divergence of opinion, because so we have 9 judges at the Constitutional Court, and 7 of them, so the decision was taken unanimously, but we had 7 judges who wrote the majority opinion and 2 judges who wanted to offer a concurring opinion. So they did not dispute the fact that the president's decree is an administrative normative act, so it has the power of law, it is a binding act, but they diverged when it came to the control that can be exercised upon it. And basically the majority opinion said that it cannot be controlled by regular courts, as it concerns an act of the president in his or her relationship to parliament. So normally in Romania, all administrative acts, right, can be controlled by regular courts, even normative acts, of course. But there is this exception, not when the act concerns the relationship with parliament. And the court said this decree concerns the relationship with parliament because parliament has to approve it, has to pronounce itself on the very establishment of the emergency state through this decree. So the court says parliament should exercise that control. And they also said subsequently, it is us, the Constitutional Court, that we will eventually exercise this control because we have the right to control the decision of the parliament. And interestingly, they concluded that the president acted ultra vires because he adopted, not when he established the state of emergency, this was perfectly legal, constitutional, but in the decree itself, the president also inscribed a series of measures that were to be implemented immediately. And the court said this was ultra vires. So the president, of course, he can institute the state of emergency, but he cannot adopt a series of measures that could have only been adopted through a law as an act of parliament. For instance, the president decided that to suspend the activity of all courts, except for in cases of emergency. So just for a special in some special situations, the courts could have still decided heard cases and so on and so forth. And then it also concluded, very interestingly, that the parliament failed to exercise its control upon the president because basically what the parliament did, they just approved the decree. They said, okay, it's all right, we approve it. And the court said the parliament should have realized that in that decree, there were some measures that were ultra vires, and they should have sanctioned it. But they did not draw any consequences from this. So if you want, it was more of a obiter dictum discussion. It was not for the future, maybe, you know, but it did not have any consequences, concrete consequences for this crisis, because they said that in this case, we have to decide upon the constitutionality of a statute. This is what the people's attorney asked us to do. And basically, they moved on to analyze every claim of the people's attorney. Now, the concurrent judges had a different opinion on this, and they said that this decree of the president can be controlled by a regular court of law. And moreover, they explicitly said, these two judges, that the Constitutional Court has no right, and it's not within its competencies, within its attributions to control the president's decree. Okay. When it comes to the constitutionality of the statute, so the infra-constitutional legislation that regulates the state of emergency, what did the court say? There is in this legislation an Article 9 that simply, I'm just summing up. It simply says basically that all the measures that are inscribed, that will be inscribed in these military ordinances, all the measures that I provided for in the legislation itself, in this piece of legislation from 1999, they are binding. Okay, this is, just, I would suggest common language. Of course, they are binding. I mean, they are law. They are not simple recommendations. But it was Article 28 was actually much more problematic, because it said failure to respect Article 9 shall constitute a contravention and shall be punished by a fine of, you see there, approximately 400 euros to 4,000 euros for natural persons, and much higher for moral persons. And also at point 2, it provided for supplementary sanctions, confiscation of goods, temporary shutdown of an activity, prohibition of access to specific premises. And this is already very bizarre, because you have an article that stipulates a contravention, and you don't really have a behavior at Article 9 that is provided for. You just, at Article 9, you just have an information, namely that all measures are binding. And what happened in the military ordinances that instituted all the measures that we already know: social distancing, and so on and so forth, interdiction of public gatherings, schools, the measures that basically were taken in all countries, of course, with various particularities. So in these military ordinances, you had the specific behavior, which constitutes a contravention. But when it came to the sanction, so, okay, what happens if I disobey the law? Those military ordinances, they simply referred to this Article 28. So basically, it was impossible to tell for which deed, which sanction do you have. And this offered a large margin of appreciation to policemen, to the people on the streets who had to implement and who had to apply fines. So if the deeds themselves were quite easily identifiable, they were not correlated with the precise sanction. And this, of course, is an infringement on the principle of legality, which is established inscribed in Article 1 of the Romanian Constitution. So it was not surprising. This was clearly a very deficient formulation in the legislation. And the judges also said principle of proportionality is also infringed, not necessarily because the fines themselves were high, because actually this mass media presented this as such. Oh, the court said that the fines were too high, so this is not legal. It's not actually about the level of the fines, but it's more, it had to do with the fact that you were unable to correlate the deed with the sanction, with the punishment. And of course, in this case, you could easily end it up with people having to pay bigger fine, higher fines for deeds that were actually of a less dangerous than other people. So it was a huge, so many uncertainties when it came to the implementation of this Article 28. So this is, let's call it the visible part, the part that has to do with the rules themselves. And now I think as in many cases, beneath this surface, beneath this legal surface, you have an invisible part. You have the iceberg, right? The visible part, the legal one, and what's beneath it, it's invisible, but it's there, and it's somehow like a foundation. And I would like to talk a bit about this part, the invisible part that I call legal culture, or the cultural layer. So as soon as the disease reached Romania, as soon as we had the first cases, this was beginning of March, it became quite clear that criminal means were going to be a part of the arsenal to contain the disease. This is probably not unseen, but I think there are some problematic aspects in the Romanian context that have to do with culture, with legal culture. First of all, you could get the sense from what mass media was presenting, you could get the sense that, well, there is a vast array of criminal acts in relation to the disease for which you can actually be prosecuted and maybe even convicted. Just to give you, and some of them seemed a bit absurd. For a lawyer, they really seemed absurd. Maybe not for the regular citizen, but at least for the lawyer, it seemed that this is a bit to the extreme. For instance, you had a case when a criminal file was open in REM because apparently someone from the ministry leaked the news that the schools were going to be closed, which actually happened the next day. But it was considered, prosecutors considered that this act of leaking news was susceptible of spreading the panic in the population, and this was a criminal act. And they launched an investigation to see who did it, who leaked the news which was public the next day. So this seems a bit absurd. Then, to give you another example, there was a guy, a former politician, businessman, quite known. He was simply against the measures. It doesn't matter. Okay, maybe he's just, crazy, stupid, but we're still living in a democracy. And this guy, he just wanted to protest against the measures. And he decided to go in a community of Roma people that were placed in quarantine. So they were, because I think they came from abroad, so they were placed in quarantine. And he went there and he embraced them and kissed them, hugged them, because he said, I want to get the disease. See, I will be fine. I want to get the disease. And he declared that after I'll get the disease, I mean, after I did what I did, I will go home and I will self-isolate. So I will not try to infect other people. But he's now being prosecuted for this act. So apparently now in Romania, let's just assume that this COVID is terribly dangerous and kills you instantly. Now in Romania, it's not legal anymore to suicide yourself, right? I mean, you can do it. You can suicide yourself if you want, but not by COVID, by something else, right? If you want. So this seems a bit absurd. And then nowhere perhaps was this militarizing and criminalizing ethos more problematic than when applied to hospitals. So when one of the hospitals in the northern part of the country became a place of high-rate infection, the management was dismissed, and immediately the hospital was militarized, and military doctors took control of the hospital. And actually what happened is that these military doctors compelled the other doctors to undergo through treatments that can be qualified, I would suggest, like humiliating in any case, and possibly even degrading in a legal sense. To give you just an example, they were compelled to shower collectively in the morning. In March in Romania, it's quite cold in the morning, in some special units of decontamination, and they were made to walk naked from those special units of contamination through their equipment rooms. And actually, some of those doctors, they spoke up and they said that they don't find it, this is not a normal situation. Of course, we want to contain the disease, but this is not the way to go about it. And to be honest, the public did not react, so it didn't catch the public's attention. And here I think it squares with what we know from statistics. So a journal conducted a survey. Of course, it was not a big survey, 1,000 people, the cohort, but still 66% of those people declared themselves in favor of the militarization of hospitals. And another problematic aspect when it comes to this penal reaction, penal attitude, is how it was applied in respect to minorities. So Roma people were beaten by the police. And again, and this is what scares me, it seems that a majority, I do not have the statistics here, but I would venture to say that the majority of Romanians agreed with this behavior. They were beaten because they simply did not respect the quarantine rules. And this was, the police manner to deal with it. So I would suggest that it's possible to qualify what has happened in Romania during these 2 months as a form of penal populism. I had recourse to the definition from John Pratt, penal populism outrage. For instance, he says it's a way of ensuring that policy in the sphere, in the criminal sphere, is more reflective of the public will than values of criminal justice establishment. And to be honest, I have the feeling that this is what happened in Romania. There was a demand from the part of the public for the state to intervene brutally with this kind of penal military means. And prosecutors they responded to this. So it was a demand and a supply. Prosecutors, they just supplied what the people demanded. And actually, there's another fact that might uphold this view, the fact that in Romania, the army enjoys huge rates of confidence from the part of the population. So the army and the church are the two most respected institutions in Romania. So now, to conclude, I think it's, of course, we have to ask ourselves why. What are the factors that could account for this kind of penal or maybe even military populism? And I have identified a series of factors that have to do with culture or even legal culture, if you want. So, of course, this whole military ethos, it goes back so it stems from old history. It dates back to the authoritarian past. And I'm not just, by this, I don't have in mind only the communist past. Also, the interwar period was also marked in Romania by this kind of governing by exceptional measures, governing by the state of emergency was declared quite frequently. The military dictatorship of Carol II also was a dictatorship based on this kind of military means. And even when the communists took power, so this purging, many people were convicted for crimes against the constitution, and you still had this military basically spirit and even military adjudication, right? Civilians convicted in military courts even. So it has to do with old history, but it also has to do with, I would suggest, this is a bit speculative. I think more work has to be done here, but it's maybe a starting point with new history as well. And by new history, I mean, you might be surprised, anti-corruption. So Romania just decided to build for itself the image of a country that has finally decided to efficiently resolve the matter of corruption, So under, of course, the guidance of the European Union, we implemented a series of measures. Some of them were very efficient, but in any case, prosecutors, they felt encouraged to go after high-profile politicians, and this actually transformed them somehow into public heroes. For instance, Laura Codruța-Kövesi, who has been elected chief prosecutor of the newly European Union's Chief Prosecutors Office. She was applauded, celebrated in Romania as really a public hero. And there was the sense that fighting the prosecutors can actually can set the country straight, something that politicians are unwilling or even unable to do. So you had this feeling that everything can really be resolved by criminal means, from corruption to COVID. And I think we have here a very problematic aspect, because actually I cannot dispute, and I do not deny that huge progress has been made in this part when it comes to anti-corruption. But behind closed doors, many legal professionals and even common people, they knew, for instance, that prosecutors sometimes used abusive methods. And even we discuss, and it's still a matter of controversy, whether they used or not mass surveillance techniques. But again, the public somehow, although there were rumors about this, not improper behavior and abusive behavior, illegal behavior from the part of prosecutors, the public was not really impressed. They seemed, they were ready to put to one side this transgression. So even if maybe they knew, they considered that it was necessary. And this is, I think, problematic because it has to deal with the way we perceive ourselves. And I will conclude with this. So my final remark, the one that I also inscribed in this slide, another factor, so it's old history, of course, a country's history marks its present, newer history, but also an ethos, an attitude that is somehow inscribed, I believe, I'm afraid, in Romanian mentality, this kind of, and possibly even in Central and Eastern Europe, this kind of self-deprecating ethos. So the idea that we Romanians, we are, savages that have to be really governed by force. And it doesn't really matter if that force is not constrained or controlled by law. It's brute force, it's necessary, and it has to be there. And in cases such as the COVID crisis, I think you could see this very clearly. So it was very visible. If in the past, maybe it was not that visible, and we can discuss if what the prosecutors did was unbelievable, successful, to be praised or not. In this case, I think it's quite obvious that this kind of penal populism associated with this self-deprecating ethos, it's something that should be, in my view, at least corrected. So in this case, I would suggest that we have to do with bad legal culture, right? Okay, so this is all. I will just be happy to respond to any questions you might have. Thank you very much.
Thank you very much, Alexandra. Do you hear me well? Because I changed the phones in order to hear me better. Mm-hmm. Okay. Alexandra, it was a great presentation. And right now I see one hand. It's Bojan Spajic. So the first question is from Professor, and maybe I will give floor to someone else.
Thank you, Mila, and thank you, Alexandra, for a great presentation. You touched, I raised my hand immediately when you mentioned the Prosecutor's Office. If there was one thing that everybody was following in the last 5, 6, 10 years, was the Prosecutor's Office in Romania. And this is an interest. So most of us, okay, I also read cautionary tales about the overstepping of boundaries with prosecutors and the use of old inherited techniques among prosecutors and the possibilities like that. But I was wondering actually, like, so obviously the role of the prosecutor's office in fighting corruption and the proactive stance of the prosecutors in Romania hasn't stopped since your former prosecutor became the European prosecutor since the end of her term of office. It would seem that a serious institution was developed and it still stands like that. Could be on that at least part of that is based on penal populism and stuff, etc. But the way I understood it in Romania, the idea was, for the most part, that what was being held in check by the prosecutor's office is the especially cases of high corruption. Yes. Civil servants, even judges, but especially politicians and stuff like that. Do you think that in this situation, this, let's say, this strength of the prosecutorial institution gave you an advantage, or it became a disadvantage when a state of emergency is declared?
Yeah, so yeah, that's an excellent point. So I would be I'm quite confident in asserting that it became a disadvantage. So it exactly, you framed it perfectly. So it used to be an advantage, well, with some small, it depends on whom you ask. Yeah, some would say unacceptable, mass surveillance was there. And the European Union knew, they just, rubber stamped it, and they said, okay, it's fine, you have to get rid of corruption, do whatever you have to do. We close our eyes, and when you're done, okay, we will congratulate yourself, and you will have your prosecutor's office in, yeah. But it worked, actually. It worked, and no one can deny this. So it used to be an advantage. And probably, hopefully the COVID crisis will pass, right? We will get by it, and it will be an advantage again. But in this case, exactly, when you have a state of emergency, which is, we have to admit it, based on a sort of illegality, not necessarily illegality, but illegality, because you have the sovereign that decides, all kinds of people who normally do not legislate, but they start taking binding measures. It's definitely a disadvantage, and I think you could see it. So again, this was even interesting at the level of rhetoric. You had the media, TVs and even newspapers. They were kind of presenting in parallel the obvious number of cases and death toll, and on the other part of the screen, or at least, in the lower top of the screen, lower part of the screen, you had the number of cases, penal cases that prosecutors are now investigating, and said 10 new criminal files have been opened today. And this was presented as something worthy of praise. Look, our prosecutors, they are there, they are doing their job. And this is something that people enjoy, actually. People enjoy. And even you do, of course, remember our protests, our long series of protests. I was there in the street as well. But at some point, I felt I wanted to distance myself a bit from the people from my age, who actually, they had really this rhetoric. No, we have to convict them, put them in jail. Well, and this is, and it had to do, it seemed that it applied to all the political class. They just said, politics is dirty, all politicians are the same, just put them in jail. And this is something problematic. And especially so when it comes from young people, because, okay, maybe our parents were somehow traumatized by the communist past, and we didn't have, illustration, and they would really want to get rid of all these, bad politicians who are corrupt. It could be justified in their case, but from young people who should be a bit more used with the language of law, the language of, maybe presumption of innocence, I felt it a bit, a bit as a disadvantage, as you mentioned. Yeah.
Thank you. Nina Kršljanin is having the floor. The second question is hers. Nina, do you hear us?
Sorry, I forgot to unmute my microphone. I started talking. Thank you. So, as I said, but nobody heard, I have one question and one remark, or rather, a call to discuss a certain issue. So, the question is, you've mentioned that one of the things that cannot be done, or rather, one of the liberties that cannot be restricted during a state of emergency is free access to justice. I was curious how broadly that is usually interpreted, since you later said that most court activity was suspended, and I generally find that reasonable in the case of a pandemic. The same situation was in Serbia, but did someone try interpreting that as restricting the free access to justice? Do you want the second one right away, or?
Yeah, I could because I think I can.
The second thing was your example with the man who voluntarily infected himself, and your remark that does it mean that suicide is now illegal? Well, what do you think if someone tried to commit suicide by blowing himself up with a bomb, or using a poisonous gas or something else, and failed, so he's not dead? I think that person could still be persecuted for causing some damage or causing general danger and so on. And I think there is reason to interpret this situation as something like that, because even though this person intends or claims that he intends to self-isolate after that, it still can't be denied that every infected person presents a slightly greater risk of infection to the general population. You never know what might happen and how he might come into contact with someone else and infect them in turn, and so on and so on.
Thank you very much. So actually, to my knowledge, no one has, as of today, interpreted that part, free access to justice. But there has been some talk, at least I, for instance, discussed the matter with a scholar of constitutional law, and we were asking ourselves in precisely the same question that you asked. Does this mean, so if the president decided to basically suspend all courts activity with the exception of some cases that were considered to be emergency cases, does this mean that the free access to justice has been restricted? Well, this is really hard to, it's very hard to draw the line. In my view, could be because, well, first of all, the president did it. So basically he legislated this, and he didn't, according to the Constitutional Court, he should not have. So it should have been Parliament, first of all, who could have the institution that could have restricted the access to justice. And on the other hand, I think it's probably you could interpret it like this because it was left to the discretion of the Supreme Court to decide which cases are considered to be urgent and which not. So it's quite a lot of uncertainty there. On the other hand, it depends on what part of that structure you emphasize, because if you emphasize free access and not necessarily access, so it's about the fact that it's free, you don't have to pay for it. Okay, then of course it would it's still free, right? So there's no problem. But it has not been interpreted so far. I would be curious to know what your view is on that, but maybe I should answer the second question, and then you can just offer your answer. So when it comes to this guy, yes, of course, the situation that you described would be one that endangered the public. So, okay, you can commit suicide, but you have to take care to do it in a way that does not pose a threat to the other or to the public, of course. But in this case, so I think they started the investigation, first of all, before knowing that the guy has or has not the disease, and without actually checking whether he really self-isolated or not. And I think this is quite, so it's kind of a preemptive criminal investigation. So he declared that he will self-isolate. At least in my view, you should have operated some checks before announcing that you're opening a criminal investigation. In my view, it was a hazardous, so it was just too quickly. Okay, you could have waited a bit and see what this guy is doing. Is he just strolling around in town? Because, you know, other people in Romania, you did not have total isolation. We were allowed, for instance, to go to work. And, well, who knows? Maybe you have the disease and you went to work. So it was a bit, and this idea of just, you know, assuming that he got the disease from these people, because those people, they were not declared, you know, they were not confirmed cases, were just isolated. So I found it to be quite problematic. And of course, I can see the distinction that you wanted to introduce, but I don't see it applicable in this case.
Okay, thank you. Regarding my opinion on the free access to justice issue, well, technically speaking, I think the free access to justice was restricted in this case. I just think the restriction is justifiable under these circumstances. But of course, if the Constitution expressly says that it cannot be restricted in any way, that's problematic. But then again, what would we do if there was a different type of natural disaster, if there was a great earthquake, if there were no physical conditions for the court to work? Then okay, that would be an impossibility, but still, I think the restrictions are reasonable in this case. Either you seem to be muted now, or...
I'm good. Can you hear me?
Yes, now I can.
Yeah, maybe they were in this it's an infra-constitutional legislation, right? And so maybe they were too and it seems that these 4 categories, they seem to be absolute rights, right? So you cannot restrict them under no circumstance, right? If, of course, we're talking about a state of emergency, maybe they were just too ambitious. And somehow you're right, because in some cases it would be just impossible for the state to still grant access to justice. Okay, maybe not in this situation, it's not that severe, or we don't know yet, but we can, of course, imagine other situations in which the state could not grant that access. And so probably, let's imagine a case like that coming before the European Court of Human Rights. It could be that the state could win, even though, because that you just have infra-constitutional legislation, right? It's not as if it cannot be trumped by what the European Convention of Human Rights stipulates. Although, if you interpret it as being more favorable to him, because we have this provision in the constitutions that international provisions regarding human rights apply. They take precedence over national constitutional provisions, unless the national provisions are more favorable. So, yeah, in that case, even if the European Court of Human Rights would be quite generous with the state, it's still somehow, so the Constitutional Court could somehow make the case that, well, our constitution is more favorable. So, yeah.
Thank you. Third question is from Miodrag Jovanovic. We have 10 more minutes, So just to let us know that we will finish in 7:20.
Thanks, Mila. Thank you, Alexandra, for very interesting presentation, and I really like how you put it in a kind of a larger context, the whole discussion. But nevertheless, I would like to return to this strictly legal part of the problem, to the Constitutional Court's decision, and just to basically to clarify certain points. Maybe I didn't get it quite right. In the part which was, as you said, mostly obiter dicta reasoning of the court stated that the measures which were proclaimed in the very act of the introduction of state of emergency were ultra-virus measures. And despite the wording of Article 93 of the Constitution, which speaks of the measures, of some measures, without identifying the nature of the measures, which are to be taken by the head of the state, and again asking Parliament for the approval within a maximum period of 5 days following its adoption. On what grounds the reasoning was that these measures, these specific measures, were ultra-virus, since the Constitution itself does not specify the type of measures? Probably this is the kind of the ground for the court to speculate on the nature of those measures. That's the first question. And the second question, those claiming that this was majority opinion, claiming that the measures are not under scrutiny of the regular courts. This, I suppose, was reasoned on grounds of Article 126. Am I right? The judicial control of administrative measures taken by public authorities is guaranteed by the courts, with the exception of those acts which concern the relations with Parliament and the military command acts. But my question is then, are those measures under no judicial scrutiny then? Because the majority claim that it's not under the scrutiny of regular courts, and the concurring two voices, they disagree on that, but they were claiming that this is not for constitutional courts to interfere. So who would be actually, by the end of the day, in competence to scrutinize those measures? Because probably nobody thinks that those measures should be under no judicial whatsoever scrutiny, or maybe like that. Okay, yeah. Thanks.
Yeah, thank you very much, Miodrag. So as regards your first question, exactly, they kind of speculated on the wording of the Constitution that is not, well, very precise. Of course, it's a constitution. We deal with general terms. So they said that the president can, of course, institute as such the state of emergency, but then he can inscribe in that state of emergency some measures, but not measures that basically amount to legislating. And they invoked separation of powers. They said nowhere in the Constitution the president has the power to legislate under the exception, even under the exception, the emergency state. It's for the parliament to do it. So, okay, you president, you declare the state of emergency, and then it's parliament through law. And actually they invoked this part 2 of Article 93. They said this is the reason why Parliament is compelled to be in session, to have the possibility to enact the various measures, restrictions of liberties and rights, and so on and so forth. So yes, if you ask me, I think the court kind of said that the only thing that the president can do is just, Article 1, one article, I declare the state of emergency. Not more than that, despite the fact that the infra-constitutional legislation endows the president with some leeway. At least, for instance, it grants him the power to state which rights can be restricted. Okay, as regards your second question, so they said that because the act concerns the relationship with Parliament, to be honest, in my view, this is quite far-fetched. It's not because Parliament controls the measure that it's a relationship with Parliament. They said that the control will be exercised, first of all, by Parliament itself. So Parliament has to read the decree and see if the president acts constitutionally or ultra-virus. And if the president acts ultra-virus, the Parliament should veto the decree, should not, approve the decree. And then they said it's us, the Constitutional Court. So in a second, so this is the first step, Parliament's control, and then we can actually control Parliament's decision, and through this control, basically, it's under our competence to finally control the president's decree. But I would side with the interpretation of the two concurring judges, and I would suggest that it can be controlled by regular courts. Except that now the Constitutional Court said it, so now it's it's in the case law. But again, is it ratio decidendi or not? It's not. It is a question. The object was something else. There was the constitutionality of this. So, for the future, I would just suggest that you can make the case that this part of the court's reasoning is not binding.
Thank you very much. Since we're out of questions and out of time, I will now close today's session. Thank you very much, Alexandra. It was great speaking, and I hope that we will see you in Belgrade soon. And I hope that we will see each other next week on the next Belgrade Legal Theory Group meeting.